Hello and welcome to Indus Special. I'm Meshal Malik. Recently, a controversial measure took place in the Philippines, which lowered the minimum age of children who can be charged for criminal activities. The age has now been lowered from 15 to 9 years old. This law has been widely criticized by child rights activists and the Commission on Human Rights. UNICEF termed the move as being an act of violence against children. In light of this event, discussion and debate has been stirred regarding juvenile justice and whether or not children can and should be criminalized. In today's show, we will try to understand this issue better. To explore this issue, we are joined by our esteemed guest. We have with us Barrister Francis Hoar, who's a lawyer joining us from London. We also have in the studios Ahmar Majeed, who is an advocate. Thank you so much for joining us. Barrister Francis, I'd like to begin with you. How can we define in legal terms juvenile delinquency?
Well, the first thing to mention in relation to the report that you just raised and the change in the law in the Philippines is that a number of countries do have different ages of criminal responsibility. And in a sense, this is a binary thing because one has criminal responsibility at that particular age. In England and Wales, and I think also in Scotland, which is a different jurisdiction in Britain, it is 10 years old, which is almost as low, but not quite, as the Philippines, which I note the criticism that has been raised. So on the one level, there is a binary distinction between having criminal responsibility and not being able to be prosecuted at all. But on the other level, there are a number of different distinctions which one can make as to how children are treated. And so while there is that binary distinction, on one day a child can not be prosecuted for anything, on the other day he or she can be prosecuted for anything at all, the treatment that they receive does depend on the age that they are at. Under 18s in England and Wales are normally tried in a different process in youth courts. They can be tried in front of a jury, but when they are tried in front of a jury, particular procedures apply. And in addition to that, there is a gradation as to the way in which they're treated, which is due to the fact that judges, magistrates and judges in the Crown Court dealing with the more serious cases, the much more serious cases in the case of juveniles, have a responsibility to ensure that the trial is fair and to ensure that trial processes are fair. And how that is dealt with will very much depend on the age of the child. So that is not a binary distinction, and that is something that will have to be worked out according to what the trial is. So I think it is important to recognise that there are these two things. One is inevitably a binary choice as to where one has the age of child responsibility. The other is the much less binary distinctions, which include, of course, also the prosecution's responsibility to decide whether or not it's in the public interest to prosecute a child. And obviously the age of that child will be a very important consideration in that decision.
Yes. And Mr. Francis, you mentioned here how it varies greatly from region to region. Even in the UK, it varies. In Scotland, the age of a criminal liability is at 8. What can you tell us about the international standards in place in trying to create some sort of a standard, a sort of a benchmark?
Well, I note the United Nations agency that criticised this standard. There are, of course, discussions as to how one can deal with juveniles, but I think it is largely dependent upon the member states and their responsibilities and the way in which they interpret the UN Convention on the Rights of Child and so on. There isn't a specific international convention saying that it is wrong, for example, to have child responsibility as low as 10, as it is in England, Wales, or even 9, as it is in the Philippines.
Barrister, in this case, the UN does state that a minimum age of criminal responsibility below the age of 12 years is considered to be internationally unacceptable. So, of course, they have laid out this claim, and it leaves to the member nations to whether or not they agree to it. But there, of course, is an international, if not a consensus, but frowning upon a lower age than this.
Yes, I agree that there is, and obviously that is an aspiration in international law. It's been declared to be unacceptable, but member states such as the United Kingdom have not signed up to responsibilities to reduce it. One needs to look at that convention and that and the attitude to juvenile detention and juvenile prosecution in the light of international standards. But each country will have to come to its own decision as to what it does.
And I take your point there, Barrister Francis. Hold on to that thought. I want to move to our guest here, Mr. Majeed. Mr. Majeed, when we look at prosecution being taken place, what nature of reasons are responsible behind juvenile delinquency, largely?
Juvenile delinquency has various reasons generally when we talk about. When we see in Pakistan, generally poverty is the main driving force which results in juvenile delinquency. Children coming from the poor are more prone to criminal activities because they have limited resources. But in general, a crime can be committed by anyone. A rich child can commit a crime. There could be a difference of nature of crime which they commit. A rich child might be driving or illegal underage drive, might be involved in underage driving, and a poor child might be involved in a theft of petty crimes. So it depends upon your class, your nature, what's your background. So there are multiple reasons behind this.
But when we look at an age group that is lower than the age of 12, what are mainly the reasons responsible for that?
If we see the data, or if we are able to go to any jail inside Pakistan, you'll see that children are inside the jail for all sorts of crimes. They are in there for murder, they are in there for petty crimes, they are in there for drug peddling. So you cannot just say that under 12 is more likely to do a certain offense and over 12 is unlikely to do a certain offense. The difference or the relaxation the law generally provides is that they set a minimum age, and then there is a maximum age under which all children who are in conflict with law must enjoy certain processes, certain benefits which the criminal justice system should provide them, considering that they are children.
And the United Nations Conventions on the Rights of the Child is one of the first laws to be implemented in terms of children. Barrister Francis, I want to ask you, what does that specifically say about the legal rights of children?
Well, amongst other things, the need to ensure that children have the support of their guardians, the knowledge and awareness of their guardians, and that's something that speaking from England and Wales, there is a responsibility to ensure that interviews, for example, are conducted with an appropriate adult, which will normally be the parent, but could otherwise be another appropriate adult nominated by the child. That also, those appropriate adults must also appear beside the child in the court process. Speaking in domestically over here, the other important process is that courts are held in private. Normally held in private. Where they are not held in private in respect of much more serious crimes, the children who are prosecuted are given anonymity. That is something that can be overturned and is sometimes overturned on their conviction, but never before their conviction.
Okay, so anonymity is key there
rights.
During the process.
Anonymity is very, very important, yes. And the reason for that is because there is a view that it is particularly important for children who might have become involved in criminal activities, depending on whether they're convicted or not, to not have their future tainted by the public reporting of their prosecution, even if that they eventually are convicted. And normally they will retain that anonymity if they are convicted. And obviously, if they are not convicted, it will not be public knowledge that they've been prosecuted, unlike as is the case for adults.
Yes, and you mentioned the necessary presence of caregivers or a guardian who is nominated by the child. But what happens with children who don't have guardians or caregivers?
Well, in England and Wales, the norm is to appoint a social worker. Where children live away from their parents, they will normally either be fostered or live in homes, and that is occasionally the case. Where they're fostered, normally the foster parent would appear. Where they're in homes, they will have a designated social worker, and that social worker will appear on their behalf. And that is the kind of standard that should be applied internationally, and that is the aspiration that the UN Convention has to ensure that children have the kind of support that gives them the ability to understand the process, have it explained by somebody who is familiar to them, because obviously they will have a lawyer, they should certainly have the right to legal advice, but that legal advice needs to be able to be understood in a sort of lay process by a parent or a guardian or somebody who is able to have their confidence and their support in a more nourishing way, and be able to make them understand the process. Definitely. That's very important. That's a very important standard.
And Mr. Francis, I do want to talk more in depth about the legal procedure that takes place when children are prosecuted. But before that, on something that you've mentioned, I want to ask Mr. Majeed that he talked about whether or not laws are understood by the children who are being prosecuted. How unfair is it to prosecute children who have no knowledge of the law, who do not even understand it, who might not even know that what they have committed is a crime?
Yeah. The general rule of the law is that ignorance of law is no excuse. So even if a child is committing a crime or adult is committing a crime for a law, a crime is a crime. Only relaxation which a child gets is to see whether he is mentally mature enough to be able to know the consequences or understand the consequences of the act which he has done.
And what measure is taken to determine whether they are mentally mature enough or not?
The minimum age of criminal liabilities throughout the world are set at different age. Like we were discussing the Philippines, they have reduced it to 9. In Pakistan, it's the minimum age is 10 years.
But does that determine your maturity level?
There are 2 steps. One is that you can be held liable if you commit a crime at 10. Between 10 to 14 under Pakistani laws, a judge has to see whether that child had the mental maturity to understand the consequences of that act. So in a way, there are 2 parts. If a child under 10 commits a crime, he does not get even arrested. The police should not even arrest that child. Okay. Because he's considered immature, and there's no question about whether he had or had not the maturity to commit the crime. When he's between 10 to 14,
is this for minor and major offenses both?
For Pakistan, it's across the board. For any offense, if a child is between 10 to 14, the judge has to see whether he had the mental maturity to understand the consequences of that crime. So in a way, when a trial starts, the judge, if he sees that is under 14, he should ask certain basic questions to understand the maturity level of the child. And if he thinks that the child is fit for a trial, then he should proceed and the prosecution and the trial should commence. Other than that, he could be exonerated at very initial stages under the Pakistani law.
Okay, so I take your point. So mental maturity is seen to be a factor when the legal procedure is being taken place here. Barrister Francis, is that the same case throughout from where you're from?
Yes, it is more or less the same case. And certainly there is an important distinction in criminal law between what's called actus reus, the act, the criminal act, and mens rea, which is the mental understanding of that act. And in nearly all criminal offences, certainly the kind of criminal offences with which children are likely to be charged, that there is a mental element, and you must establish that the child either intends to do something or that they're reckless as to whether or not they can do it. They can't be guilty of an offence if they did not intend or were not reckless as to how it would happen. That's a fundamental part of the law that applies for adults as well. But in respect of children, a part of their defence may be that they don't understand it. But as my colleague just said, it's also important to establish where there is a doubt as to whether or not the child understands the offence and is able to understand the criminal process, to examine that. And there is a procedure whereby that can happen in England and Wales as well, in order to ensure that those children who do not understand the process and are not mentally mature enough to be able to have a fair trial as a result are not put through the criminal process.
Yes. And Mr. Francis, I'm curious, where do you stand on the debate of whether or not the minimum age should be raised, and if you agree with it or not?
Well, as I say, I think the fact that there are other safeguards in place in order to establish whether or not children do understand, do have the mental maturity is important, and in a way is almost as important as the binary decision as to whether or not one has criminal responsibility at 10. I agree. I have represented one child who was age 10 for an allegation of theft, but it is extremely unusual for children to be prosecuted under the age of about 12 or 13. At that age, it becomes much more common. 15, for what it's worth, seems a very high age. There are a very large number of teenagers, as it's appropriate to call them, age 13 and 14, who do commit crimes, and frankly, there is considerable evidence that they do understand, at least to a certain extent, at least to a sufficient extent, that what they're doing is wrong, and that and are in many cases repeat offenders, and those who do need to have some measure of instruction and monitoring through the criminal process, rehabilitation, which is the focus of punishment of children. So I think 15 is certainly too high. 10 maybe, I can see 10 may be too low. There are cases.
So it seems like the UN's recommendation of having age 12 seems to be the most appropriate.
Well, I think that's a recommendation that the UN will have reached, having assessed evidence.
Yeah.
But like anything, where there is a binary distinction, and there are different international standards, it's impossible to know what is absolutely right. As you rightly say, each child will develop differently, and there will always need to be a gradual process whereby that development is recognised, and courts do not prosecute children who do not fully understand the consequences of their actions. That's more important, in my view, than the date of the age of the binary distinction, because if one has an age of 12, but then one automatically assumes that children are responsible without having that ability to determine their understanding, that is a much graver violation of their rights than having an age of criminal responsibility as low as 10. Although I can see that an argument can be raised that 10 is too low.
Okay.
12 certainly is as high as it should be, I think.
I take your point, Barrister Franz. Something that you mentioned in your comment was related to rehabilitation, something I will touch upon but before that, we will take a short break. Welcome back to Indus Special. While we discuss juvenile justice further, now we're joined in the studios by Dr. Alia Aftab, who is a psychologist, and also joining us from India is Anakshi Ganguly, who is a child rights activist. Thank you so much for joining us. Dr. Alia, I'd like to begin with you. So we got a legal perspective on what the age of maturity is and how the law considers it. But from a psychologist's perspective, when do children reach the mental capacity of knowing what's right from wrong?
You see, there's no defined age as such, because we psychologists, we emphasize on puberty, which starts at 12 years of age, because before that, it's too young. At puberty, there are a lot of hormonal changes within and a lot of brain development. So we define 12 or 13 years of age as not as a very mature thing, but the child is start maturing from now. He knows about his rights and wrong, about the moral activities even. But when we say the child, when we talk about children, we say that personality foundation starts at the years of 5 years.
Okay.
So when the child is 5 years of age, then we start to give training about the child, about the moral activities, about what is right, what is wrong, how to indulge in good physical activities, bad physical activities, good moral activities.
So,
also.
even in the States, North Carolina has the age of 6 for which it gives children criminal liability. In a psychologist's point of view, after the age of 5, when they start beginning to develop that sense, is the age of 6 even appropriate?
Well, I don't think so 6 is appropriate because it's too young. A child of 6 years doesn't know too much about right and wrong because it's still in the developing stage. Because especially in a country, developing country, a country like Pakistan, America is still different because it varies from culture to culture. But when we talk about our culture, here children are not given too much exposure even. In States they are, but still 6 is a very young age. If I would have been as a psychologist, I would say that 10 to 11 years is an age when the child starts to develop. Because the brain is developing till 20 years of age.
And what is that, till 20 years of that age, there's a concept behind it known as plasticity. Can you tell us about that?
You see, the thing is that there are different things about it. When we talk about plasticity, is that the age is growing. There are hormonal changes within, cultural changes within, and also environmental changes. Like what happens is that the adolescence is being developed. And when the adolescence is being developed, the children want maturity and independence. They want their own identity. So in it, the identity has to be established and they have to be given independence as such. And they have to be given responsibilities even.
So now the question that leads from this discussion is that juvenile delinquents, what pushes them? What are the environmental factors that lead to them committing crimes?
There's not one factor. There are quite a lot of factors. When you talk about environmental factors, first of all is the family. The family ties. Sometimes broken home children do this a lot. Sometimes not, but a child that is overpopulated has too many siblings and the child is not given proper attention. Sometimes when children have a lot of fights with the parents, sometimes when parents have a lot of fight, the neighbors are not very good. Like the environment in which you live, the neighbors have children which are not very good. Sometimes schools also. Like when you are bullied in school, when you don't go to school, when the changes are coming, sometimes what happens, parents ignore. And sometimes it's about nutrition even, malnutrition even. Because when there are a lot of children and they don't eat the proper diet, what happens? The brain doesn't function. They become fatigued, they become distressed, and that is when the changes, mental changes are coming within them. And that's when they think of doing something or the other that is harmful for them.
So carrying on from this discussion, I want to move on to Inakshi. Inakshi, the Philippine lawmakers who put the bill forward of reducing the age from 15 to 9 said that they know that children will be freed and that's why gangs exploit these young children, and by passing this law they will make sure children are not exploited. How would you respond to that?
Listening to your conversation, age of criminal responsibility and age of juvenility are two different concepts. The age of juvenility has been fairly established at, with the definition of the child at 18 years. And the reason, as the psychologist on the panel explained, it is because the frontal cortex of the brain of a young person is growing almost up till the age of 25. And that is what leads to impulsive behavior. But it also means that that is the age till which there can be reform. And the whole idea of juvenile justice across the world over history has been about giving children who commit offenses a second chance and a chance to make a fresh start. Now, if you are going to constantly, out of fear of public anxiety and give in to emotional heightened demand for reduction of age, what we are doing is we are making children more vulnerable to becoming, in fact, more deviant, because the minute you put them into the system and you incarcerate them and they come in contact with the system where there is very little chance of reform and rehabilitation, they are in fact going to be encouraging deviant behavior. And there is enough research now across the world that tells us that actually what children need is an opportunity to reform, to be rehabilitated, to get back into the society, for the society to become a better and a more safe space. And this is now established. But what is happening also is around, it's not just Philippines, but we're witnessing this sudden upsurge of demand from society that is criminalizing and penalizing young people. And we're moving to more and more punitive action. And more and more punitive action only criminalizes more and more. In fact, what we should be doing is moving into more restorative action, more restorative justice, if we want society to be safe.
Very important point, how punitive measures are being heightened and reformative action is not being given enough attention. I want to take this question to Barrister Francis. What do you think the law says about prevention as opposed to taking the route of punishment?
Prevention and as in rehabilitation of the individual to ensure that that individual doesn't commit offences again. Well, that is as Ms. Ganguly just said, that is the focus of the criminal justice system, at least certainly in England and Wales and in many other jurisdictions, most other jurisdictions, I hope, it is to ensure that the child is rehabilitated and does not commit offences again. And for that reason, in this jurisdiction, there is a very clear gradation. In almost all cases, the first offence will lead to what's called a rehabilitation order, which is focused on community-based supervision and ensuring that the child is punished. There is normally some form of community work involved, but does address the terms of their offending, the causes of their offending. There are other means of community punishment that happen well before a criminal sentence, a sentence of imprisonment, which is not imposed to under 16s, but under 16s can in England and Wales be detained.
Tell us about those community services.
Yeah, so there's community service, which is the element of community work. It's now called payback, where the offender works within the community. And there is also, alongside that, there will always, with children and normally with adults too, be a means of directly dealing with the offending behaviour, what's under supervision. And that may involve work with psychologists. It will certainly involve work with social workers. It will involve discussions about the reason for offending, addressing the causes of offending, looking at the offender's background, their child, their parents, their associates, whether they're involved in gangs and so on. That's very important.
And Barrister Francis, hold on to that thought. I want to ask Mr. Majeed here, while we're talking about community services and something before actually taking them to detention centers, I want to ask, following from that, when we specifically talk about detention centers, how are detention centers for juveniles different from those than adults?
If you see, there are three stages. One is the prevention, one is the actual crime as committed and the prosecution, and then the rehabilitation comes. The general law or the international standards say that a child should not be sent to a jail or detention center. If a child commits a crime, there should be separate facilities for a child where he or she is rehabilitated. And for that, certain steps or certain measures, like our friend from UK was suggesting that a psychologist and social worker should be involved. They should not be dressed like inmates. They should not be treated like inmates. If they have to be confined, the confinement should be such that it brings about change in them. The rehabilitation process, their education is continued. They have the possibility of learning vocational skills. In Pakistan, the law proposes that a similar sort of setups, that the children should not be put in jails and they should be set up in rehabilitation centers where psychologists and social workers and prosecution would work together, and at the end of their sentences, they should be better individuals other than becoming hardened criminals.
So something that he mentioned here was about how these centers should be focusing on rehabilitation. But Dr. Ali, I want to ask you, in this impressionable age, just being separated from their families alone must have devastating impacts on the child's mental growth. So what impacts does that exactly have? And wouldn't that act be counterproductive when you're trying to reform children?
That's a very good question, because what happens, children, especially if they are young, if they are about 6 or 7 years, then family is very important for them, especially mother. If they are separated from the mother, then separation anxiety also causes a lot of problems. But at this time, I think it's very important to get intervention within the family. They have to have family counseling, you know, like calling the parents, talking to them, enacting roles, giving them responsibilities, because when you give them responsibilities, they know that they have to do it, and they have to be answerable to them even. Because once you are answerable, you know that this is it what you have to perform, and I have to be answerable and I will be questioned for it. So they are responsible for that. So when the mother is also intervened, the father is also in, they have a responsibility and they have a role to play. And then it will be a family unit, and not only the family, I think the siblings also play a very important role, because sometimes the siblings dominate, or what happens, the mother gives importance to one child better as compared to the entire nuclear family. And they have to delegate responsibilities to everyone, and they have to have a lot of discussions, because we people feel that the catharsis is very important. What is catharsis? Catharsis is your inner feelings. They are very important. So we have to delegate those.
Yes. And something that Dr. Alia has mentioned is alluding towards the prevention of juvenile delinquency. And to that, I'll ask you, Anakshi, what can society do to prevent children, underage children, juveniles from committing crime in the first place?
You know, the Indian law is an interesting law. The Indian law is about, and it follows the welfarist approach. It deals with two categories of children: children who are in need of care and protection, and children who are in conflict with the law. The reason for this is that the vulnerability of children who are in need of care and protection, for whatever the reason, that they are marginalized or have been exploited, they need to be brought into the system so that they do not at any time become vulnerable to coming in contact with the law as an offender. And that was the reason for bringing the two sets of children into the act, but treating them differently under two different systems. They don't come under the same system, they come under the same law, but the bodies and the systems that address their needs are completely different. So that was the preventive part of the Indian law. I mean, we are maybe ideal in our construction of the law, but we are far from that in implementation. But the fact is that we must understand that the environment shapes the children. And many of us, as we have grown up as young people, may have done something that was not strictly following the law, but we never came in contact with the law, or we were not treated as offenders because we had the privilege of a family or somebody who supported us and moved us away and diverted us from the system. But many of these children who are actually coming in contact with the law are ones who do not have that privilege of being assisted in that way. So therefore, diversion and restorative justice have to be an inherent part of a robust juvenile justice system. Similarly, the access to services of the most fundamental basic services of education, health, that create a support structure, a protective environment for children where they do not fall out of the protective net is equally important, so that they do not become vulnerable to offending.
So, Anakshi,
having said that, I think it's important to understand. But people believe the juvenile justice system allows young people who offend to walk. And I think I want to take a minute to reiterate that it is not this. The juvenile justice system is a different system for dealing with children, but it is about holding children accountable. It is about stopping reoffending. It is about telling children that you have done something that is wrong, you're accountable for it, but you will get another chance because you're young. And that message needs to be clear, because it is not clear. That is why we find this heightened demand for changing juvenile justice laws and reducing of ages. And I think that is a very, very worrying trend that we are witnessing.
And actually, on that point that you're saying that it's important for accountability to take place, I want to ask your insight on to something that Amnesty International has also pointed towards, which is that there's little attention drawn to how children are mistreated during the process of the judicial process. They are often tortured, ill-treated in police custody. They are forced to give confessions. What can you tell us about that?
It's so true, and it's particularly, I would say that it is true of South Asia, but we also know that it is equally true of the United States of America. There is a huge ethnic and caste bias in the kind of children who come into the system. The privileged children often do not come into the system. They face double jeopardy of the punitive action of not just the law, which is sometimes long winding and very, takes forever, with high pendency rates. It also is there is a violence in the system that these children face right from the time when they come into the police custody and through the system, and which does nothing to enhance their, respect and their belief in the system. It only makes them more deviant in their behavior, because they become angry, and what they witness is violence against them, which then they will perpetuate. What the system is not telling them, that you are here and we will support you. You made a mistake, we will support you to get back into life as a responsible citizen. What the system is doing is treating them with stigmatization and criminalization.
And then actually, hold on to that thought. I do want to talk about reintegration, but something that you mentioned was this class and ethnic bias, and I want to ask Barrister Francis his thoughts and his opinion on that.
I think Ms. Ganguly just mentioned a very important point, which is that there are many children from disadvantaged backgrounds are far more likely to come into the criminal justice system for offences that would never be prosecuted for privileged children, because privileged children will be disciplined for it within their schools and within their families. And that is an important point to make, because it is inherent to the fairness of the justice system that where a type of offending behaviour that should be dealt with in school, that is typical delinquency that shouldn't involve the police, shouldn't involve the criminal justice system, is dealt with in the school and is not prosecuted. And that's why it's very important for the prosecution services to be really rigorous in deciding whether it is in the public interest to prosecute. In terms of the wider question as to what we can do to stop crime, that is an enormous question, of course, that goes to various elements of social policy. We have a problem in London, as in many cities, with gangs, and the gang development of children, which I think was mentioned earlier in the context of the justification. I think you mentioned the justification that the Philippines has for bringing children into the criminal system is that they are that there is some sort of focus on them and that they can be removed from gangs, and that's not an entirely wrong point. And dealing with that gang culture is for the more serious.
Barrister Francis, I hate to interrupt here, but in these gangs, many children are coerced, and incidents of child trafficking exist. So they do not have agency to choose. So how are you preventing them from getting into something that they did? You're punishing them for a decision they didn't make, they were coerced into. Isn't that unfair?
Absolutely. That's a very important consideration. If they are forced into it, they would have a defence in law, but also that would come into the decision as to whether or not they'd be prosecuted. But I think the reasoning for the Philippines, and I'm not saying I agree at all with the necessarily with the way they've dealt with this, but the reasoning is to be able to allow the police to focus on these sort of gangs and to investigate the behaviour, which is perhaps more likely to happen if they can decide where some children who are perhaps over the age of 12, but perhaps under the age of 15, do need to have some form of criminal intervention, because there is that, which hopefully will have a very rehabilitative focus, which will be a more effective way of moving them away from the gangs that they are in. But obviously that is only where it is appropriate to prosecute them, and where they are found by the courts to have that criminal understanding that is necessary.
And that's a very important point that you just made here, Francis. And I want to take a question to Mr. Majeed here, that we were talking about the class bias, the ethnic bias that exists, and both Anakshi and Barrister Francis talked about it. How can policies change and become more nuanced to identify those children coming from disadvantaged backgrounds for the purpose of equity, not just creating a system which is fair, but trying to realize some people come from worse off conditions?
Whenever we talk about vulnerable populations or the children in conflict with law, we have to see their background. And the policy can address the preventive part particularly. There could be methods for the economic rehabilitation of the parents of the family so that the child does not end up on the street or does not end up working. And that could be avoided. Eventually, the criminality of the juvenility or the delinquency could be avoided. So policy could address that. The rehabilitation process, the policy could address the rehabilitation process that the detention as a last resort is used. When a child comes into contact with law, the detention should be the last resort. It should not be the first course of action. Unfortunately, the law does say that the detention is last resort, but the police and our system is built such a way that detention becomes the primary focus of the agencies.
And are there any centers, alternatives for detention centers, which on a parallel could provide a more productive environment?
At the trial stage, unfortunately, there are none. When the child is under trial, he has to remain in that particular jail, which is nearest to his home location or where he was arrested. The rehabilitation part, very little comes in when that child is convicted. We have separate postal institutes, but unfortunately they are run like jails rather than being a rehabilitative centers that they are supposed to be.
And if there are not enough juvenile centers available, there is a danger that children will be sent to adult detention centers?
Yes.
Can you tell us about the harms in that and what happens there?
Unfortunately, in the whole of Punjab, we have only 2 rehabilitation or postal institutes, what they are titled as. One is in Faisalabad and one is in Bahawalpur. Other than that, if a child commits a crime, he goes to that district jail, which is within that district. So each district jail has a separate juvenile section where the juveniles are kept separate from the adult. But at the end of the day, that is a jail and it is run by the principals and the law under which any normal juvenile, any prison is run. So the rehabilitative part is totally missing from that particular prison. So the law requires, the new law which we had in 2018 says that there has to be separate observation home when the children come in contact with law, and then a separate rehabilitation centers where the children would be eventually sent if they are convicted. So that needs to be implemented so that the children do not come in contact with the hardened criminals. Unfortunately, we do keep them separated in the prison, but when they are transported to the courts, they use the same vehicles where the adults and the children are coming from the court to the prisons in the same van. So that really increases their vulnerability. The chances to reoffending increases. Again, when they are at the court, the lockup which they have, that's the shared lockup again.
And Dr. Alia, on that point of how they come into contact with hardened criminals, what impact would that have on an impressionable mind? It seems almost as if going to jail will lead them more towards the path of delinquency.
Exactly, I do agree with you, and I really am against this because children should be separated from the adults because they have very innocent minds and they are still in the developing states. When they are with adults, obviously adults will have more power on them, and not even more power, more influence of them.
And abuse as well.
And abuses as well, because you see when children are small, they look up to the elders, and usually they copy the behavior of the father and the mothers, even of the parents. So when they are forced to, and they will be abused, so they will have no other option rather than to defy within them, and this will increase. You know, I went to the jail of children and I saw them. They were really innocent from their faces, but when you talk to them, because they have been staying 24/7 with the adults, and the environment is not going to be very friendly, the environment is also going to be abusive and very hardcore criminals. So it's going to leave a very bad impression on their minds, and then rehabilitation will be very difficult for them. Because habits are going to become permanent within the subconscious mind, and then it will be very difficult for them. And then when they go out, they will not be a productive part of the society. So we need to have some interventions, some preventions, some sort of strategies, some psychological programs where we need to educate them, where we need to tell them what is right and wrong, we need to tell them about their moral duties, and we need to bring the family institution together even. And we need to make them strong on their own, because what happens, they become insecure. And when they become insecure, they succumb to all these bad things.
Yes. And Dr. Alia, you talked about the importance of reintegration, and I want to ask Anakshi here, how can these children who have come out of juvenile centers, detention centers, how can they be reintegrated back into society?
The only way to do that is to give them a chance. As long as then they are stigmatized and it is believed that they are criminals forever, they will never ever be reintegrated. But if one of the ways of doing it, at least in India, is that there is an expunging of records, and there is anonymity that is established for young offenders. That is the way we've been trying to do it in India. And it's
Can you
part
tell
of
us
the
a
law.
little more about the expunging of records here?
So in no order. Suppose if I have to get an order on a juvenile, on an young offender, the names are not there. It would be saying offender number 1. No names, the names of the parents, nothing that identifies the young person is included, is allowed to be in a public space for anyone to look at. So we will never know who we're talking about, even if you were to look at an order. Then the orders are kept in a certain place, and after a few years, it's about 7 years, that the orders are complete. The orders are completely destroyed, so that there is no, and the child begins because one of the ideas is to give the chance for a fresh start. Of course, all of this is being contested because, as we have seen, because it's like you said, the tragedy is the children are paying the price for a failure of a system, because the system is unable to give them what they need in terms of rehabilitation, in terms of reformation, in terms of the skills, and therefore reintegrate them into society.
Yeah.
What they go back with is the same violence. And so reintegration becomes that much more difficult.
We're running out of, so I want to pose the last question to Barrister Francis here. What can the international community do? What can the policy makers do to ensure that the system becomes more fair, it becomes more transparent, and children are not mistreated? What needs to be done urgently?
I think the focus needs to be on rehabilitation. And what I think I've gathered from this is that there may be in many countries laws that ensure, that supposedly provide for rehabilitation, but the importance is that those laws are actually implemented and that the resources is directed to ensuring that there are, for example, children-only borstal or rehabilitation centres, that there are sufficient social workers to work with children, because it is all very well to change the law if one doesn't have the resources and doesn't direct the resources to be able to do that. And I think that's probably the most important thing to do. One can always work on new conventions and have high aspirations, and that's important. And I don't suggest that that's not something that we need to do as an international community, particularly where there are some countries, and unfortunately Philippines, which was mentioned at the beginning, is a particularly bad example of a country in recent years in the way in which its criminal justice system has worked generally. But that is all very well if those high aspirations and laws are not able to be implemented. So I suggest that rehabilitation is the most important thing.
Rehabilitation is something that all our guests have stressed upon. And thank you so much for joining us today and discussing this important topic. Thank you, Mr. Majeed. Thank you, Dr. Alia. Thank you, Barrister Francis. Thank you, Anakshi, for joining us. Hope you liked today's episode, and we will see you again next week. Goodbye.